Well, I wanted to turn to practical implications and the idea that from the claimant that if you were to do anything other than choose English law, that would have implications that were absurd or unworkable. It's that broad issue. I wanted to start by just giving you one reference that I probably should have given you earlier on in response to some of the questioning from Lord Stevens about the possibility that you might have to split up the injury into different countries and how would you go about doing that and the difficulties potentially of doing that. Just to show you at least how the pleading works in that respect. If you go to page 311, which will take you to paragraph 109 of the amended points of claim. You will see under particulars of injury how the claim is pleaded. And the short point is that there isn't any attempt or suggestion that there were discrete elements that would have to be split up between different countries or whatever. It's just a blanket claim for damage in that way and for injury suffered in that way. And then the claim for exemplary damages is likewise put across the entire period as a common or global thing.
But is that's because at this stage nothing more is known?
My Lord, it may be, but that's the only pleading we have at the moment. And as I say, it doesn't seem to...
It seems an unusual proposition that the defendants would be liable for all the damages, all the personal injuries sustained over a protracted period of time.
Well, my Lord, that may be so, but that's the way it is pleaded currently.
Well,
and all of the allegations of mistreatment earlier on in the pleading are all in common form as well as between the various different temporal periods. At the moment, there isn't any distinction of that kind, or it's just simply done as a global claim, as it were. The present claim, of course, is unusual in the sense that there are a number of countries, rather than just a kind of binary choice, a number of countries which engage the default provision under Section 11, or the general rule under...
Before leaving the pleading, then page 280, paragraph 36E, I think at some earlier stage you said that the connection with this country was that the security services just pressed send. Slightly more extensive than that.
Yes, well, my Lord, that's and the pleadings are as they are. I mean, yeah. The central focus, as I say, is on the provision of the questions, and that goes to...
Well, devising...
I'm told by everyone on my left, including Mr. Herman, that it's a generic claim rather than specific to this case.
Okay.
That helps.
Okay, can I just check, do we have the order identifying the preliminary issue in the bundle?
We should have somewhere on the call.
I don't want to take up time on it now, but if we could be given a reference at some point, it'd be useful.
It's the case management order. So it's a bit difficult to track from the hard copy versions I've got of the index.
Yeah, if one of your many assistants could identify it for me.
Page 178, thank you. Yeah, page 178, I hope should do it. Paragraph 2.
I see. So that was agreed as the issue.
Yeah, simply the
okay. Thank you.
It doesn't define it, does it?
Oh, no.
It doesn't define it.
Sorry.
A further issue that's troubling me is that while we have these particular countries that have been identified in the pleading, as I understand it, that those are countries which this claimant has done his best, or those assisting him have done his best to identify from public sources. But there's no acceptance that those were the particular countries in which he was in fact held. nor, as I understand it, there an acceptance that particular activities took place in any one of them in relation to him. And so, while it is known that he was, on this assumption, held in different locations in these notional black holes where he was in fact subjected to torture on this assumption, can one be in any degree certain at this stage that it was in those particular countries, in those black holes? Is that an issue that is going to have to be resolved by this claimant at the trial, and in relation to those countries as it emerges from disclosure or in such other way, allegations would have to be made about the relevant law in those jurisdictions?
My Lord, you're right. There is no acceptance at this stage about anything of that in open. But at the moment, those are the countries that the claimant has identified by reference to the sources that you've indicated. And
doing the best he can.
Doing the best he can, of course.
But his primary case is that he's been held in different jurisdictions over which he had no choice or no control at time periods which he is unable to identify with precision and in relation to which no admission has been made.
Well, my Lord, that's true, although he has identified those 6 countries. That is the nature of the pleaded claim. We assume for this purpose that those allegations are true, including the locations in which he was held. The advantage, it might be thought, of a CMP and an order under Section 6 is that if the position is that there were other countries, or it comes to light in that way that there are other countries, there may have to be issues sorted out about that. So one can't be certain. I entirely accept that point. But at the moment, we have the 6 countries, and even at its most general, even at its most uncertain, the point is that no one has ever asserted there's a connection to the UK in that respect, other than in the sense that you've seen. So there would be foreign countries, so there may be less of a list, there may be more of a list, you're right. We don't have finality on that issue yet. But none of them go to the United Kingdom, and what you're doing is comparing the factors that link one set of countries to the other.
Do you accept that if he were held in a location where there was in fact no effective remedy under the law of that jurisdiction, then that would be a relevant factor to take into account under Section 12?
Well, it could be. I mean, I've been having a look at that issue over lunch again. It could be. What you've got to do is to, under the relevant statutory scheme, is to compare the significance of the factors which connect a tort or delict, so that's presumably the English tort or Scottish delict equivalent, with the country whose law will be applicable under the general rule. And there is at least a question as to what the position would be if there was no civil law that was applicable to the conduct in a particular case. There might be an issue of interpretation arising under Section 12.1 as to what you would do in that situation if the comparison was there, whether it would be a relevant factor, whether it wouldn't be a relevant factor. My submission is that you don't have to grapple with that issue here, because on any view, given the alternative pleading, there are in fact 6 countries in which there is in fact law which responds to the facts of these claims on the claimant's case. And so I'm not at the moment taking any particular position, if I may put it this way. I'm not taking any particular position on what the position might be under Section 12 if you ended up with a void. The point that I was seeking to address before the short adjournment was whether there was legitimacy in saying it's a factor which may go in some ways or in some circumstances to loosen the connection to the foreign country, that it didn't have those laws, rather than the point my Lord has just put to me, if that distinction makes sense.
But if he were unable to identify any particular country in which he was in fact held, albeit in a black hole, then what would be the appropriate law to apply?
Well, then you would have a choice were that to be the position. You would have to say, well, either we plump for English law on the basis that there is nothing else and no one has asserted anything else, or you jump into Lord Stephen's camp and you assert US law on the basis that they were the primary actors.
Not my camp. Well, it was my proposition.
Of course, well, I wasn't seeking to ascribe it to you as a suggestion, but
yes.
Sorry, to overdo it.
What's troubling me is the notion that because you accept certain matters as pleaded for the purposes of your application, that there may be a logical gap between that position and what in fact was the case in relation to the locations where he was held in black holes for this purpose by, as you would put it to us, primarily at the hands of other Secret Service agents. With what degree of certainty, or how appropriate is it to consider the laws of any one of these particular identified jurisdictions doing the best he can from public sources is the relevant law to apply for this purpose?
Well, my answer to that is that this is a stage of litigation where the rules of the game are set. And the rules of the game are that you assume the facts pleaded to be true. And the facts pleaded against me, and it's the only basis on which the court can proceed at this stage, because we're not finding facts. That's absolutely clear. So you proceed on the basis of the assumed facts. And the assumed facts are that the mistreatment, the conduct, and everything else occurred in these 6 countries. I've already made the point that it's not the UK. Now, if the position is that it ultimately turns out that there are other countries, or a lesser number of countries, or whatever it may be, then no doubt that is a set of issues and that is a set of circumstances that would both be capable of being sorted out and would be sorted out at a later stage if and when it arose, and then matters might have to be kept under review. I mean, VTB in the Supreme Court positively made the point that this is one of those issues you keep under advisement.
I see.
And you would need to, but at the moment, I'm afraid, my rather stark answer is that the rules of the game have to be played in accordance with them. And the rules of the game at the moment are assume the facts, and those are the 6 countries.
Thank you.
And as I said earlier, I hope trying to draw the distinction not too subtly in relation to the exchanges we had before, the short adjournment as well, and the exchange in which Lord Burrows and Lord Sales were asking me questions as well. The analysis in section 12 involves comparing the factors connecting the tort to the country. And it isn't immediately obvious that the difficulty of establishing ingredients of the foreign law, my submission would be that if there are difficulties of that kind, that isn't a reason for not selecting that foreign country as relevant.
Just on that, can I ask you, what's your position where, I mean, as often happens in conflicts of laws, you don't have a precise mirror between the law of the foreign country and the English law of tort? I mean, how does one address that sort of situation where, let's say, the law of Morocco has a law of personal injuries, but may not have a law of misfeasance in public office or something like that? How does section 11 and 12 work in that sort of situation?
My submission is that if you've got that disparity, that is simply a function of the substantive nature of the foreign law. What this set of rules is designed to do is not to determine the state of foreign law. There are provisions which allow you to look at that for the limited purposes set out in section 14, namely if they operate in a manner which would be unacceptable in accordance with principles of English public policy. So, for example, if they were discriminatory, the example I gave earlier. But my submission is that if they don't have a particular cause of action, or if the cause of action is more difficult for one party than another, that's normally the reason you're having the fight. The point is that under the legislation, this is designed to enable you to select that system of foreign law, and you can't drag in a potential disadvantage to one party or the other of the substantive foreign law which is thereby selected. That's just simply the end point of the exercise.
So how does it work? I mean, do you look then to see, well, whether there's a cause of action in Moroccan law in respect to personal injury, and even though it's different, the ingredients may differ in various respects.
Yes.
It's sufficiently the same that it is then a relevant, viable candidate to be the applicable law.
My Lord, I think that would have to be the case, although I'm reluctant to accept too much even in relation to that, because certainly the Law Commission in advance of this legislation were very clear that to use the difficulty of establishing a foreign law as an argument against a choice of law rule would be going too far. That would not be the right answer.
Right.
So let me just invite you to turn that up very briefly, if I may. If you go to page 1623, not on exactly this point, but it's pretty close to it. Look at paragraph 419, if you would, and 420.
Not so much the difficulty of proving foreign law as it is
It's a substantive
non-existence of.
My Lord, yes, but that's to some extent that comes back though to the point I identified earlier, which is what is the reference to tort or delict in 12.1a, for example, or 12.1b? What are you doing? It looks like the reference there is to the English tort, or an English law of tort, or a Scottish law of tort, and if that is right, then you're, as it were, taking those ingredients and comparing them. But it would be very surprising if the position under Section 12 allowed you to throw into the balance a possible disadvantage to a claimant in the substantive nature of the foreign law.
Yes, I mean, that must be right, mustn't it? I mean, if you just think about a personal injury case, I mean, often these cases are fought. Let's say we've got very low levels of compensatory damages in jurisdiction X, and the accident occurs to, let's assume, a claimant who's English in jurisdiction X. The fact that it's going to be the claimant's massive disadvantage for the applicable law to be of jurisdiction X is neither here nor there.
A lot of my respectful submission is that must be right, because the nature of this exercise is to determine which is the applicable law, and the applicable law is telem quælem. You take it as it comes. That's the. So my respectful submission is that on its natural reading, you take the English law of tort, as it were, that is alleged, if there's a comparison, and you look at the connection between those ingredients and one jurisdiction and another. The state of the substantive law is irrelevant, I submit. And indeed, it would be very odd otherwise, because people, as you say, don't normally have these sorts of disagreements unless one law is perceived by one party as being more favourable to it than another.
Yes. So, James, can you help me with this? I'm having some difficulty with the idea, that the tort of misfeasance in public office, when committed by an English civil servant, could be governed by a foreign law. By the law of Morocco or Poland?
My Lord, I'm not sure I share that difficulty, respectfully. It may well be that you don't have an identical concept, but you may well have a concept of misconduct of some kind by public officials.
The question would be, if this conduct had been performed by a Polish civil servant or a Lithuanian civil servant, would it have been actionable?
By a public official there,
A public
yes.
official, yes. Right.
I think that's the way it would have to work.
Thank you.
It's quite strange otherwise that there would be a lacuna for that tort alone, and the only applicable law could be English law. I respect for submission that isn't the way it works. You look at the broader comparison under Section 12, and if there is something equivalent, so be it. I mean, to some extent, these are all interesting and difficult issues, but it might be thought that the shortcut through all of this is that there has in fact been pleading against us under the foreign law systems which covers the torts that are alleged. And so to claim in those circumstances that the position is unworkable or impractical, it doesn't contain a balance. I mean, we're not in a situation where someone is seeking to argue before you or has ever sought to argue. This is all thoroughly disadvantageous. The balance should be struck in a particular way because we haven't got an equivalent of misfeasance, or because it's more difficult to establish the tort of negligence or its equivalent in Morocco. That is not the way this has been run. The proof of the pudding is in the fact that, well, I say the proof of the pudding, the proof of this particular pudding is in the fact that it has been pleaded. And there are equivalents, and they have felt able to do that. The choice is therefore between one system of law and another.
But one wouldn't have thought that the operation of sections 11 and 12 depends upon there being a precise match between the relevant laws. Maybe the law of Morocco doesn't have a law of negligence, so you couldn't plead it at all, but has a law to protect someone against harm to the infliction of personal injury.
Yes. But maybe the answer then, I agree, maybe the answer is that what is actually being done in Section 12 is to pose not an impossible comparative exercise or a wholly unrealistic one, because one wouldn't expect equivalence or identicality, but is rather to say focus on the English law of tort or delict, identify the conduct which is alleged, which goes to that, the loss, the causation and all the rest of it, and compare the connections of those elements, because that's the thing you can do, with the foreign law, and you strip out the advantages, disadvantages, or even existence of the foreign law in question in an equivalent scenario. Because otherwise it does become either impossible or impractical, or as it were, entirely undermining of the whole process, because you're not going to be into this debate unless someone thinks there is an advantage or a disadvantage.
Could you just direct me to where on the pleadings the equivalent of misfeasance in public office is actually pleaded for the other jurisdictions?
298.
Sorry, I think 298.
218 was it?
218.
298.
298, thank you.
Paragraph 57 is tie.
Yes, thank you.
But if you you say 12A and B is concentrating on the tort as known in English law, and so far I think I agree with you. The issues arising in the case, are those the issues arising under the tort of England, English law? That is substantially more appropriate for the applicable law for determining the issues arising in the case. A and B are English law. Is the next part also English law?
I'm not sure they can be, can they? Because you're making a choice and you're looking to see which of the two systems of law applying the connections properly.
What does case refer back to?
The case refers to the claim, but the claim could have foreign law pleaded and it could have English law pleaded. And the issues arising must comprise both, because otherwise you wouldn't have a debate.
Yeah, I mean, it seems to me that Section 12 is based on the idea you've got two viable contenders of law to be applied to the issues in the case.
Yeah.
So it's not presupposing that it must be the English law issues, because that's the very point which is to be determined by applying Section 12.
Yeah. So you look at the underlying, essentially you have to look at the English law of tort or delict, then you see what the ingredients of that are, you see what conduct that chimes with, and you look to see what the connection is between those, between the one jurisdiction and the other. That's the way it must work, otherwise it wouldn't make sense.
Reference in Section 12, subsection 1 to the issues arising in the case, or any of those issues, might suggest that it's possible to segregate the issues.
It is possible to do that, and the Court of Appeal, if you recall in VTB, I think one of the factors there referred to that. Certainly there is reference in VTB to that possibility, that you could have different answers depending upon what you were looking at.
That's not advocated for.
It isn't, massively.
By
There are complications enough. It isn't, but my Lord is right in principle. That appears from the face of the statute and was commented on, I think, in VTB, I think in the Court of Appeal.
Thank you.
If we could have a reference at some point for that.
I'm sure I can try and find it now. I thought it was in those sections that Lord Clark had quoted, but
Oh, in the Supreme Court.
I think it's in the Supreme Court, but quoting from the Court of Appeal was my memory. But
Page 777, I think that was.
notoriously faulty, so. No, it doesn't matter all it was. Can we find it? For
Yes,
you and then-
please. Thank you.
And then give you that reference. Sorry. Well, my final topic was going to be previous case law. And I mention it briefly. And I mention it briefly because the Court of Appeal were, we accept, of course, right to conclude that none of that case law was binding on them, and a fortiori, therefore, it isn't binding on this court. And they're different facts, or they were to some extent different facts in those cases. But we do nevertheless submit that there are real similarities between some at least of those cases and the present context, perhaps unsurprisingly because this is a set of issues, a set of allegations that has been troubling the courts here for some years now. And you will remember well the facts of Belhage, in which the allegation was that there was a more direct involvement by the United Kingdom services in the rendition concerned. And so it's unsurprising that the courts have addressed these sorts of issues before. And my respectful submission is that for all their non-binding nature, they do provide those cases, or at least some of them, helpful comparative indicators as to how the court should go about striking the balances under Section 12 and dealing with these issues. And the point in its broadest sense is that they are, those cases, all in one direction. In all of them, the general rule said foreign law in one or more countries, and there was an attempt to disapply that, relying on Section 12, and that failed. Sometimes it was agreed that it should fail, and so it failed, but in all of them it failed. There is at least some force, I accept, in the idea that struck the Court of Appeal with particular force that at least two of those cases, Serdar and Al-Jeddah, were rather different, because in those cases the claims were about detention, pure and simple, and in both of those cases the relevant local law had been altered, to use a neutral phrase, so as to take account of obligations and rights under the UNSCRs that governed the military operations that were taking place in those countries. Lord Lloyd-Jones will remember well some of those issues from earlier litigation. So leaving those aside by way of direct comparator, I still say there's useful material in both of those cases, but the two cases that are of real interest in terms of at least closeness of comparison are Belhage and Rahmatullah. Now, Belhage, you will remember from all the litigation and all the reports and so on, you'll have seen it referred to both in the judgment of Mr. Justice Lane and in the judgment of the Court of Appeal. You'll probably remember the way in which that was disposed of and all the various issues it gave rise to. Rahmatullah was the case that ended up first in the Supreme Court on the habeas argument, as my Lord I'm sure will recall, in which Lord Kerr gave the judgment, and there's been a recent reprise of that in the Divisional Court, I think, and the Court of Appeal on cases called C3 and C4 about the Syrian camps and habeas there. But that was the case about the individual who had been picked up by British soldiers, handed to the Americans. The Americans then transferred him out of Iraq, where the military operations and the NIAC was taking place, to Afghanistan. And And there was, if you will recall, an MOU between the Americans and the British, under which, at least on one reading of it, the British were entitled to call for an individual back. And the habeas reasoning was, in a nutshell, that that gave the UK sufficient control so as to engage the habeas jurisdiction. There were then personal injury proceedings brought on the back of all of that, but those were the basic facts for present purposes. On the back of all of that, there was then this debate about sections 11 and 12. I'm not going to go back through the relevant authorities themselves, that is the section 11, section 12 analysis in Belhaj and in Rahmatullah, but may I recommend to the court as a full summary at least, which should give you almost everything, if not everything you need, of what the facts of those cases, those two cases were, and how the court disposed of them in each case. If you go back, if you would, to the judgment of Mr. Justice Lane, page 162 in the electronic bundles, or if you have it loose in the hard copy, you will see that he starts with Al-Jeddah at paragraph 24, and then for present purposes the interest is in the judgment of Mr. Justice Simon, as he then was in Belhaj.
Sorry, Mr. Justice Lane at paragraph?
Paragraph 24 it starts, which is Al-Jeddah.
Thank you. Yes.
You have that? I'm not going to trouble so much with Al-Jeddah. I'm going to focus on Belhaj and Rahmatullah. He deals with Belhaj at paragraphs 25 and following for the next 2 or 3 pages, or 2 pages up to the final quote at the top of page 164. I'm not inviting you to read all that now, but it's a helpful and good summary of what Mr. Justice Simon decided. And was upheld in that by the Court of Appeal. Effectively, the conclusion was that the general rule applied, the injury occurred.
Sorry.
Injury occurred in the foreign countries, so the general rule applied under section 11, and it wasn't displaced, not even close to being displaced, by section 12. That was the reasoning and conclusion upheld by the Court of Appeal. So that is that one. And then Rahmatullah is dealt with by Mr. Justice Lane again quite fully, setting out extensive citations or quotations from Mr. Justice Turner's judgment. That's at paragraph 38 of Mr. Justice Lane's judgment, and it runs through, you'll need to read the Mr. Justice Turner analyses of Rahmatullah. It then runs through pretty much to the end of paragraph 42. Yes. So that's where you get a summary of those two cases. And then in the Court of Appeal, in our case, these other authorities were dealt with in the Court of Appeal's judgment between paragraphs 43 on page 145 and 50. So that's where you have the sections of the two judgments dealing with these comparative cases. And as I've said, focusing on the Court of Appeal's reasoning, for present purposes, the really interesting points of comparison, it might be thought, are in relation to Belhaj, which is dealt with in paragraph 45, and Rahmatullah, which is dealt with in paragraph 47. And what the Court of Appeal did was to note that these weren't binding and that no one said they were, fair enough, but then to take them take the point not as a point of bare precedent, but to seek to distinguish them for the purpose of, as it were, undermining their comparative force. That's not an unfair way of describing what they were doing. So if you look at Belhage and Straw and the analysis of that in paragraph 45, you see the first half of paragraph 45 is summarising considerably less fully than was summarised by Mr. Justice Lane what Mr. Justice Simon had done and what the Court of Appeal did in upholding him and concluding that the law of the foreign countries wouldn't be displaced. And again, there were multiple countries there, and all the same issues that we've been talking about would have arisen there, all the difficulties of doing it, and can you be certain at this stage, and all of that. All the same things arose, effectively, so they were very close by way of comparison to our situation, raising substantially the same points. And then the grounds on which the Court of Appeals sought to distinguish Belhage are then set out in the second half of the paragraph. Can I just invite you to read that from literally about halfway down? There's a line beginning, "The judge had made no error." If you pick it up at the sentence beginning at the end of that line, 2 points are important for an understanding of this case. The first is that. I'd like you to read to the end of the paragraph. So there are 2 points that are being made by way of, as it were, undermining the comparative force of this case. The first of them is that the facts asserted in Belhage involved the allegation that there was complicity. In other words, that the United Kingdom were, on any view, on the allegations there made, more involved because of the "it's the least we could do for you" point. So there was an active allegation that they were, as it were, physically complicit and helpful in all of this. The difficulty, of course, with that as a point of distinction, as compared to the present case where questions are sent, is that that fact renders the comparison with Belhage a fortiori, because the involvement alleged against the United Kingdom in Belhage was greater than it is in our case. So they are right that it's an important distinction, at least on one view, but where no complicity is alleged, but the fact that is relied upon renders the comparison a fortiori in our case, I submit. The second point, which is said to undermine the comparative force of this case, is that the context arose largely as to who had the burden of pleading the point. Again, I don't want to spend long on that, but you will note when you go back to the summary of that part of Mr. Justice Lane's judgment which deals with Belhage, that there was a positive suggestion that was made in that case, I think by Mr. Hermer, that in that context by Mr. Hermer, that the relevant issues under sections 11 and 12 in that case were obiter. And Mr. Justice Lane squarely rejected that, and there's been no challenge to that. The findings under sections 11 and 12 were not obiter. They were essential and on the critical path of the reasoning that the court set out. And so, whilst it is true that they may have been largely concerned with who had the burden of pleading the foreign law, it was an integral part of the analysis to do, in effect, the section 11 and section 12 justification. So it's a point, but it's an irrelevant point if you're seeking to undermine the comparative force of the case. So we respectfully submit that the 2 reasons that were given for undermining the comparative force of Belhage, multiple countries, lots of different things, UK security services again alleged to have been involved in these various ways in rendition and mistreatment and all of the things that we've seen in this case, substantial similarity, and the 2 points of distinction that the Court of Appeal relied upon simply don't distinguish.
Well, I wonder if that's so, because paragraph 29 of Simon J's, so of the Mr. Justice Lane's decision, records that the claimants had conceded an argument before Simon J, namely that it was unlikely the laws of England and Wales applied, for example, to their alleged detention in China and Malaysia. And so, putting it as mildest, it wasn't vigorously argued. And it's in that context that the balancing exercise is carried out.
Well,
I don't see there was any argument in relation
well, the point was contentious, as I understand it, and was ruled upon.
Well, it was ruled upon. I don't wonder about the contentious aspect of it.
Yeah, well, I mean, the reality is that Mr. Justice Simon produces a judgment which does the Section 11, Section 12 analysis, whether the argument was light or heavy, may matter less than the fact that he did it, and the Court of Appeal concluded that the correctness of that was pretty clear, and concluded...
But was it argued in the Court of Appeal that it was incorrect?
I'm not sure, my Lord, I'm sorry.
Well, I sat in the Court of Appeal in Belhadge, and...
Can you remember?
I can't remember.
Well, we'll find out.
My recollection is that the argument concentrated on where the burden of proof lay.
Yes.
But,
I think we were given paragraph numbers, maybe in 144.
To check that.
Yeah, 144 to 148. We'll check the Court of Appeal. Yes, 144 is the paragraph in the Court of Appeal judgment referred to in paragraph 29. Anyway, those aren't the grounds of distinction. Grounds of distinction are as identified at the end of paragraph 45, and neither of them is good. It's my respectful submission. And similarly, in relation to Ramatullah, which is dealt with by the Court of Appeal in paragraph 47, again, I'm not going to comment on whether or not Mr. Justice Turner dealt with the issue as the Court of Appeal described it, lightly or not, but you will have seen, even from Mr. Justice Lane's judgment and the extensive citations from Mr. Justice Turner's judgment in Ramatullah, that there was at least some detailed consideration being given to those issues. And again, you will see that the issues are very similar, with multiple jurisdictions, injury occurring abroad. The Section 12 analysis is then set out. The MOU that I referred to earlier is analysed. So there's some considerable analysis by Mr. Justice Turner. I'm not sure I'd necessarily accept the lightness ground for distinguishing the force of, or the comparative force of that judgment. But again, the same point applies in relation to the facts of Ramatullah as applies here, as applied in relation to Belhaj, rather. The fact of the matter is that, if anything, the involvement of the United Kingdom was greater there, because, as you will recall from the description I gave earlier, it's evident from the habeas judgment, amongst other things, the involvement of the United Kingdom was, if anything, greater there. The United Kingdom had held Mr. Ramatullah and had transferred him to the Americans, so there was active physical transferring on the ground, as it were, in the sequence of events that then followed. And moreover, having done so, and this was the basis for the finding in relation to habeas, they had in place an agreement which enabled them to call him back, and they didn't do that. Well, they did eventually when the Court of Appeal invited them to do so under the habeas jurisdiction and got a relatively short answer. But the fact of the matter is that the differences of fact are not, we respectfully submit, such as to do anything other than to render the comparative force of that judgment and its analysis of sections 11 and 12a fortiori. So that's what we say about the previous case law. My Lords, unless there's anything further I can assist you with in opening, those are my submissions in opening the appeal. Thank you.
Thank you, Sir James. Mr. Homer.
My Lords, Sir James teased you with the prospect of finishing today. I think that's not going to be very long, but I think that's
We weren't holding out any great hopes of that, Mr. Herman, and we've taken a lot of Sir James's time this afternoon by posing additional questions. You mustn't feel under any pressure of time.
Thank you. My Lords, the simple contention on which our response is based is that although the facts of this case are highly unusual, the application of the statutory choice of law framework to those facts is straightforward. The case is readily unlocked by the application of basic principles of statutory construction, ascertaining the meaning of the words used by Parliament in Section 12 in light of their context and purpose, and applying them to a case in which the court is asked to determine the issue of liability of the defendants for their tortious acts and omissions made by officials of this country, acting in an official capacity on behalf of this country for the perceived benefit of this country, in respect of injuries sustained in other countries selected by a third party because they permitted the operation of secret detention centres on their soil out with their own domestic laws, and in locations that were deliberately kept from the claimant as a component of his mistreatment, and whose locations were at best a matter of indifference to the defendants. My Lord, to make good what we say is a straightforward application of the statutory test, in this case to those facts, I divide my submissions into 4 parts. But I begin by identifying what we say is the correct approach in principle to the interpretation and application of Section 12. But I then turn to the core features of this case that we say is relevant to the application of Section 12. Thirdly, why the High Court got it wrong. I'm going to be short because I would have already covered most of the ground in the previous sections. And then fourthly and finally, why the Court of Appeal got it right. And I'm going to be even shorter because I'm intending predominantly to reply to the appellant's argument that the Court somehow impermissibly predicted the outcome of a disputed issue. My Lords, those are the 4 areas.
Sorry, what was that last sentence? I beg your pardon. I didn't quite catch it.
So, in respect of the Court of Appeal, I'm going to predominantly focus on the issue raised by the appellant, that the Court of Appeal impermissibly predicted the outcome of a disputed issue. That's the issue that's raised by the appellants in the Statement of Fact of Issues at paragraph 25A, Roman numeral 2, page 45. It was touched on by Sir James earlier. I could begin then with part 1 and the correct analytical approach. And can I make 6 interlocking points under this heading? First is a statement of the obvious, but I hope it merits identification. Part 3 of the 1995 Act generally, and sections 11 and 12 in particular, are drafted in very clear terms and in plain English. They don't employ any terms of art, nor do they fall to be interpreted in light of any international rules of international law or comparative law practice, nor in contrast with some other jurisdictions are the rules in Part 3 a reflection of a complex legal theory or an attempt to codify common law principles built up over time. Rather, they're designed to be interpreted by the application of their plain meaning in a way that doesn't produce absurdity or obvious unfairness. And that fits, we submit, with the purpose of the Act, which is to provide a clear, predictable, fair, and readily applicable framework for litigants, their advisors, and the courts to identify which law or laws govern the dispute they want the court to resolve. Part 3 meets those aims through the simplicity and clarity of its terms. A reflection of its success in that respect is the fact that there's been very little litigation about what the provisions mean, as opposed to whether on the facts of a given case they've been properly applied. reflected, not least in how few authorities there are before the court today. That's my first general point. My second point is about the words of Section 12 itself, and I'd be very grateful if the court would turn up Section 12, page 423 of the authorities. Section 12.1.
Sorry, just before we get to Section 12, what do you say about Section 11? Because that's the starting point of the analysis. Are you accepting that we're dealing with a case, all elements of which fall within Section 11.2a?
Yes, my lord.
Right, okay. So we don't need to worry about C or a difference between false imprisonment and actual injury.
No,
just treat it all. Okay, thank you.
Why is that?
Well, as a matter of practicality, that's the basis on which we've all proceeded. There is one element identified by Lord Justice Mayles to which a different gateway might be appropriate, which is false imprisonment. In this case, it's been taken and, I think, put on the basis that the injuries flow from that imprisonment. It's all under the heading of trespass to the person. It would be possible, and it's certainly permissible under the statutory scheme, for the allegation that the defendant is responsible for the detention of the claimant to be analysed separately under 11.2c. But for the purposes of the appeal, it's all been analysed to date on an acceptance of there's been no dispute that we enter Section 12 through 11.2a.
Thank you very much.
If I could move then to Section 12 and the plain words of Section 12, which require in 12.1 a comparison, firstly, of the significance of the factors which connect a tort in A with the country, and B, the significance of the factors connecting, again, the tort with another country. But it's substantially more appropriate for the applicable law for determining the issues arising in this case to be the law of another country. And we say what the plain words of the statute are doing here is placing and fixing the general rule, I beg your pardon, the general rule, the displacement of the general rule under Section 12, placing the focus of the court firmly on the alleged tort and its relationship with the issues to be determined. The test is markedly different, markedly more narrow than the more wide-ranging territorial analysis that would often be required to resolve a forum convenience dispute. And the focus on the tort is plain from the clear words. They ground the analysis as one that must be conducted through the prism of the tort. Through that prism, and that prism alone, that one considers the impact on of those connections on the issues arising in the case. Now, in the Court of Appeal, it was taken effectively as read that what one means by the tort in this case is effectively the essence of the tort or the gravamen of the tort. But if I may respond to a point that was ventilated by my Lord Burrows this morning, which is effectively what is it that we talk of when we talk about a tort within Section 12? Is it the damage? Is that what the tort is? Or are there other elements of the tort that are referred to in Section 12? And as the starting point is that most torts will have different elements to them. And indeed, for a case to fall within Section 11.2 in the first place, a case will have different elements, a tort will have different elements occurring in different countries. All the torts here have different elements. Negligence, for example, has different elements of a tort consisting of duty, breach, and damage. Misfeasance, an intention, an unlawful act and damage. No one element is the tort. The task under section 12 is to evaluate what the most appropriate law is to determine the issue between the parties. And that requires, in our respectful submission, assessing what is the heart of the tort relevant to that issue.
You said that the Court of Appeal used the phrase "the essence of the tort" or "the gravamen of the tort."
They used the gravamen of the tort, and
which it was just asking for a reference. Which paragraph they did that in?
Can I give that to my lord in 1 minute? It's not.
Yeah, I'm sure.
The issue in this case, the issue within the meaning of section 12, is liability. The applicable law will also determine quantum in this case, but there's no suggestion that there should be a bifurcation between liability and quantum. But the issue, as was the issue in VTB, is liability. In other cases, you can have issues in Rurik and Valiant Trawlers as an example, where the issue isn't liability, the issue is a measure of damages.
But I'm sure the issue will be both liability and quantum, won't it?
My lord, the applicable law here is likely to govern both. The focus of the submissions of the parties to date throughout has been on the issue of liability. That's the real issue in dispute between the parties at this stage, not what heads of loss are recoverable under a given law, but is the defence...
I'm so sorry to take up time on this, but won't that follow from identifying the applicable law?
It will.
So applicable law must cover both liability and damage quantum remedy?
Yes. My lord, absolutely.
Okay.
There's no dispute about that. But the primary issue that is in dispute at this stage for the parties, that it is appropriate to identify the applicable law for, is the issue of liability. And that's why one asks, when assessing what do we mean by the tort, and what are the most significant elements of the tort, that's how we calibrate what those significant elements of the tort are. The elements most significant for the determination of the issue in dispute, liability. My Lord, gravamen is at paragraph 35 of the...
Thank you very much.
That the tort can't be defined solely by reference to the damage is reflected in the approach of this court in VTB, where it held that English law applied. It wasn't simply because the damage occurred. They looked at what the essence of the case was, the intrinsic nature of the tort, and I'm going to show my lords that. It would also be hard to reconcile with the relationship between section 11 2A and section 12. Because if the tort is always going to be the damage, then we would wonder why it would ever be possible to displace it under section 12. But it must mean an evaluative analysis of what the heart of the complaint is. And in that context, tort should be taken as broadly meaning a civil wrong. What's the heart of the context of liability? What is the heart of the wrong that's said to form the dispute between the parties that the court is asked to resolve? It may be thought in our submission unsurprising that the focus is on the parties before the court in a private law claim and the heart of the dispute between them, because the law is being applied to determine the private law rights of those parties. It's their rights and liabilities that are in issue. My Lord, the focus of the statute on the tort and on the parties and on the issues before the court continues when we turn to section 12, subsection 2.
Is this still your second point, is it?
It is, my lord, yes. Just on the pure statutory construction. So, Section 12.2 gives a direction that the court, when considering the factors connecting a tort with the country, should focus in particular on factors relating to the parties, obviously a reference to the parties in the case pending before the court. It then directs particular attention to the events that constitute the tort in question. And again, we would say most relevant to the issue for which the applicable law is going to be used to determine. And again, the tort in question is obviously, I beg your pardon, is obviously the heart of the question. The tort is the tort pleaded between the claimant and the defendant, not some other tort not in question before the court. And the final words of 12.2, referring to any of the circumstances or consequences of those events, refers back through the events to the events which constitute the tort or delict. So at every turn in Section 12, the focus is on the tort's connection, and the question as to whether it is appropriate to apply a law having regard to that by reference to the issue that needs to be determined, or issues that need to be determined.
The last submission is whether appropriate to apply
the law to the issues that will be determined.
I still don't quite follow, I'm sorry, the point that Lord Sales raised, and that is, well, this is a claim for liability and for damages.
Yes.
And so one asks the question, substantially more appropriate for the applicable law to determine the issues arising in the case. Those issues are both liability and damages.
They are.
Right. And I just wonder where we get into this concept of the primary issue being liability as opposed to damages.
Well, my lord, maybe it's not actually necessary for my case to prioritise one over the other.
Yeah.
Certainly an issue before the court is liability.
Yes.
And the question that I want to focus on my submissions would be, what's the appropriate law to determine liability in this case? I would accept that whatever law that is highly likely also to govern the scope of damages.
But I'm not quite sure why you break it down in that way.
Well, the reason I do that, my lord, is because my submission is that when you seek to apply the term tort in this case, you seek to identify the components that are most relevant for the determination of the issue. So for a quantum aspect of the case, one could see that the locus of the injury could determine the outcome if the issue is quantum, but on the facts of the case, say a fact similar to this one, you could reach a different decision in respect of liability. I don't argue that here, but I do argue from the starting point of it's useful and helpful to identify the issue here as liability. I don't know if that makes it more confusing or less confusing.
Well, I'm struggling here slightly because, to me, liability means that one's got to consider all the elements of the tort. Now, in a case that's a tort that's actionable only on proof of damage, you do not get any liability unless you've shown, for example, in the example you gave of negligence, duty of care, breach of duty, causal non-reload damage.
Yes.
That's the liability question. So it's not clear that I understand why your distinction between liability and damages is going to make any difference, because I would have thought everybody's accepting, and James Eady was stressing, you need to look at all the elements of the tort, all the elements that go to liability.
Well, my respectful submission is that when one's looking at the issue of liability through the prism of the tort and through the prism of the test in Section 12, one is looking at what the essential elements, what the gravamen of the tort is, most relevant to liability. So that's
And
not.
how do you
that's-
answer that? Sorry, and what, to cut to the chase, is your answer to that? What are you saying is the gravamen of the tort?
Sending of requests for information to be extracted in the circumstances that it was. If someone was to ask, and I can put it in the most rudimentary way, but it's a fitting way, we would say, in a statute as simple as this, if you were to ask, what was it that the defendants did that gives rise to liability? The answer to that is the sending of the requests. That's the heart of the tort.
If I said to you, I'm driving down a road, and you would say to me, what is the gravamen of the tort? Applying that analogy, it's when I negligently drive.
Yes.
But if there's no damage caused, there's obviously no tort. So how can you say the gravamen of the tort is just the conduct? It just seems to me you can't do. You know, speaking for myself at this point in time, I'm not sure I can see that one can separate out in the way that you're trying to do one element of the tort as more significant than the other. They seem to me they're both, or they're all essential. One is no more important than the other.
Well, my lord, certainly, for the purposes of establishing a tort, they are all essential.
Yep.
And it is meaningless when they are all required to be satisfied to say that one is more appropriate than the other. My lord, entirely accept that.
Okay.
But that's not the purpose of what is being required under Section 12. What's required under Section 12 are some evaluative judgments. And you need to identify the significance of factors that connect a tort, and you need to apply a qualitative assessment as to whether it would be substantially more appropriate in light of your comparison for determining the issues arising in the case to apply a foreign law. Now, at that stage, for the purposes of those evaluative judgments, it is permissible in our case to stand back and say, well, what are the most significant elements to determine liability, the issue of liability? Is it the fact that damage was sustained, of course a necessary ingredient for most but not all of these torts? Or is it, when one's determining whether or not the defendants should be liable, their rights and liabilities engaged, is it more appropriate for determining liability to look at the other elements of the tort, what they did and what they didn't do? Because that's what's being judged, that's what the applicable law in respect of liability is being utilised for. It's to calibrate the legality of their behaviour.
But I don't understand this argument to be necessary for your case at
It's
all.
not.
It's not.
It's
and,
not.
And if I may say so, at the moment, I think it's a bit of a red herring, because the statutory requirement is for determining the issues arising in the case. And I'd be more interested in what is meant by in the case. That is in the claim
Yes.
they made.
But look,
Is it?
my lord, yes, the case is the case brought by the claimants against these defendants for what they did and did not do.
Yeah.
But my lord, the reason I was seeking to identify that a tort will have different components, and that depending on what the issue is that law is asked to determine, some of those components may be more relevant than others for a Section 12 analysis. The reason I'm doing that is really arises out of an observation of my Lord Burrows this morning, that it's all about the damage, and that's the tort.
Section 11 requires personal injuries being sustained.
Yes.
And Section 12 is an exception to that.
Yes.
So, you of course, the sustaining of personal injuries is not determinative. You then look at the other aspects of the tort and where they were committed.
Well, I think my Lord has just encapsulated what I was struggling perhaps to say in a pithier, a more elegant way.
Right, but I mean, speaking for myself, it's difficult to say that the location of the damage drops out of the comparative exercise in Section 12. I'm not sure that you're saying.
No, I'm not going anywhere close to saying that.
And just to, in relation to what Lord Stevens was asking about meaning of issues in the case, I mean, you say the case is the claim against these defendants, but that covers both issues of liability and quantum as well.
It does.
And in particular, for the reasons given by Lord Burrows, liability will depend upon establishing damage. So it's very difficult to draw any very hard and fast distinction between liability and damage. They flow into each other both as a matter of procedure and as a matter of legal theory, don't they?
Yes, to an extent, my lord. I mean, it would be most unlikely that one would address this question by asking first, what's the law likely to govern quantum, and then say, well, it must follow, if it governs quantum, it will govern liability. It's much more instructive, we say, on the facts of this case, to start off by identifying what laws would govern the issue of liability, and then asking, is there any reason it would differ in respect of quantum? But what this case is really all about at the moment, and where the applicable law is really being fought, is what law governs the calibration of, in legal terms, of what the defendants did or did not do.
So as I understand the submission, I hope I didn't say this morning that the tort was simply about where the damage occurred. I certainly didn't mean to say that. It was an important element, is what I would want to have said, and I misspoke if I did suggest that. But as I understand your submission, you're accepting all these elements, that is, conduct and damage, at least if we've got a tort actionable only on proof of damage, are essential and important for the establishing of the tort. But when you come to look at how we apply Section 12, certain elements or factors you are going to say are more significant than others on these facts. And on these facts, you're suggesting, as I understand it, that it's the conduct element rather than the damage element that is most significant.
Yes.
Yeah.
Because that's the heart of the tort that the claimant, that's how the claimant would say is what is the heart of the case. It's what the defendants did or did not do.
But I struggle, I really do, because it's the significance of the factors which connect a tort with the country. And the factors would be exactly what you say. One of the factors is that the defendants are here. Yeah. They are a public body exercising public powers in this country.
Well, my lord,
that's a factor. And you then take it into account when you consider whether or not it's substantially more appropriate for determining the issues arising in the case.
Yes.
And I certainly wasn't suggesting, and I wasn't meaning to suggest in any way that under Section 12, the fact that the injuries were sustained in a foreign country drop out of the picture. I mean, not at all. I wasn't suggesting that.
I think I've committed two errors. Firstly, misinterpreting what my Lord Burrows said, and secondly, taking us on a diversion that somewhat undermines my first point, which is one I maintain. This is all rather straightforward and simple. So let's leave that to a side. Can I show you on my third point, VTB? Because VTB, in our submission, is important and helpful authority for the emphasis that the test under Section 12 requires focus on the tort and not the wider circumstances upon which that tort is based. So my lords will find that at tab 8, the report starts at 710. This is a case in which the issue was one of forum, and applicable law arose because there was an issue as to whether or not it was determinative, or at least the extent of its potency, in a forum argument. So if English law applied, did that point to the England being the most appropriate forum, or conversely, if Russian law applied, Russia? That's the basis on which it arose. And it arose on a commercial dispute. The claimant bank, which was a subsidiary of a large Russian bank, entered into a facility agreement with a Russian company, RAP, to enable it to buy a number of Russian dairy companies from the first defendant, Nutricheck, that was registered in the Virgin Islands but was in all intents and purposes in fact a Russian company. When RAP defaulted on its loan, VTB brought a case against Nutracheck for the torts of deceit and conspiracy, alleging that the other defendants were jointly liable. Those other defendants were companies and one individual who were either Russian or had very deep Russian connections. And in this case, the Supreme Court, differing from both the first instance judge and the Court of Appeal, held that although the case was effectively thoroughly Russian, it was English law that applied. And they held that the Court of Appeal fell into error by taking into account factors that may be relevant to Forum in its decision that it was Russian law, but were irrelevant to the question of applicable law, both under Section 11 and under Section 12. My learned friend took you to some passages of VTB this morning, but could we just go again to a few without the need for repetition? Lord Clark was in dissent on the question of forum non-convenience, together with Lord Reid, but there was no doubting his analysis of the applicable law question.
And sorry, just for my note, so what's the majority hold on forum non-convenience? Did they say it should be Russia?
Russia. Notwithstanding that all said it was English law that governed.
Yeah, I mean, English law is just a factor, but there were other factors.
That's exactly.
Yeah.
And it was really a question of weight that should be given to that. The decisions of the courts below can be summarised by Lord Clark at paragraph 197, page 774 of the judgment.
Page?
774, my lord.
Thank you.
So that you can see that at first instance the judge held that it was Russian law applying section 11(2)(c and section 12. Court of Appeal, slightly more tentative conclusion under section 11, but nevertheless concluded that it would be substantially more appropriate to apply Russian law under section 12. At paragraph 198 through to 202, his lordship deals with the test under section 11(2)(c. Could I just, and he sets out at 198 a lengthy citation from the Court of Appeal's approach to section 11, which he doesn't demur from. But can I just, under that, it's a different test, but it's nevertheless worth looking at. Points 3, in carrying out the exercise, it's the English law constituents of the tort that matter. That's the significance under section 11. The analysis requires examination of the intrinsic nature of the elements of the events constituting the tort. It doesn't at this stage involve an examination of the nature or the closeness of the tie. This latter exercise is only relevant if section 12 is invoked. And once the different elements and of the events of the country in which they occurred have been identified, the court has to make a value judgment regarding the significance of each of those elements. Significance means the significance of the element in relation to the tort in question, rather than trying to judge which involves the most elaborate factual investigation.
We see intrinsic nature is in quote marks. Are you able to help us where that came from?
You can see that picked up if we go over to 200. Where his lordship says the Court of Appeal held that the judge had made such an error. That's an error justifying the Court of Appeal interfering, and reached a different conclusion. In my opinion, if the principles set out are applied, the Court of Appeal was entitled to interfere with the conclusion reached by the judge. As Lord Justice Mance put it in Morin, section 11 directs attention to the intrinsic nature of the elements of the tort.
Yes, thank you very much.
And you can see again, the Court of Appeal said that they judged the most important elements of the facts constituting the tort of deceit are, by their intrinsic nature, the reliance on misrepresentation and the loss suffered by VTB, and his lordship agreed. And you can see applying section 11.
Just out of interest, why not the lies themselves?
Say sorry, my lord.
It says the important elements are the reliance on the misrepresentations and the loss suffered. I was just querying.
I think, well, you can note, if we go on to 201, we can see that those lies with the misrepresentations were also made in London.
Yeah, but it's true. He's talking about what the Court of Appeal said, that the most important elements are the reliance and the loss. My query was, why aren't the misrepresentations themselves an important part?
Well, my lord, I can see that they certainly could be.
They certainly should be.
Yeah, it just seems a bit odd. But if you can't take it further than that, so be it.
You'll see, and I'll show you very briefly in a moment, Lord Mance, who actually thought this case was even more easily resolved under Section 11.1. But both Lord Mance and Lord Newburgh thought it was very straightforward in respect of deceit that it was going to be English law, because this is where the representations were made and relied upon. More difficult in respect of the case, the allegations of conspiracy, because all the conspirators were in Russia. That's where the conspiracy was concocted. But nevertheless, they assumed it was going to be English law for the purpose of the appeal. Can I move, though, from Section 11 to His Lordship's treatment of Section 12? He turns to it at paragraph 203, and he sets out a further passage of the Court of Appeal that my learned friend took you to this morning. At 204, His Lordship said, in every case to which the Act applies, in which the Court has considered the general rule under Section 11, the Court must consider whether the general rule is displaced under Section 12. There's an illuminating discussion of the general approach in Dicey. The editors say that the application of the displacement rule in Section 12 first requires taking account of all the circumstances, a comparison of the significance of the factors which connect the tort with the country, with the law in which it would be applicable under the general rule, and the significance of any factors connecting the tort with another country, here Russia. The word tort is italicised in the text of Dicey, and His Lordship returns to that in a moment. 205, 206 are the passages my learned friend took you to earlier on about the rare nature of the invocation of the exception, and I'm going to return to that later. 207 and 208 are helpful to read because they give the court a sense of the truly Russian nature of the case and the allegations. And they bring into contrast much more narrow analysis of this court. Could I just ask the court, if they'd be so kind as to read 207 to 208? And so that leads His Lordship at 209 to say that it seemed to me that in that paragraph the Court of Appeal didn't pay sufficient regard to the fact that in his paragraphs 188 and 189 the judge was not considering Section 12 but the broader question of forum convenience. Further, the Court of Appeal focused not upon the particular tort or torts but upon much wider considerations. As Dicey observes, Section 12.1 expressly focuses upon the particular torts. Here, the tort or torts as a result of which VTB suffered loss in London were committed as a result of VTB entering into a contract or contracts in London in reliance upon representations made to it in London. I entirely accept that some of the other considerations were capable of being relevant, but I can see no basis on which it can properly be held that the general rule under which English law was plainly the applicable law should be displaced by Russian law on the basis it's substantially more appropriate. In short, the claimant here is an English entity which was induced to enter into the facility agreements in England and suffered loss in England when it discharged its obligations under it. The position would no doubt have been entirely different if the claimant had been VTB Moscow. Can I just give you references to the other passages of their lordships? Lord Mance, who, as I said, thought the case fell within 11.1, certainly in respect of deceit. His conclusion is that, on that point, is at paragraph 7, page 727. Lord Newburger agreed with both Lord Clark and Lord Mance at paragraph 99, page 751. 751, my lord.
Thank you.
Lord Wilson agrees with both at paragraph 153, page 762. Lord Reed agrees with Lord Clark, paragraph 240 at page 786. And can I give you one other reference for your note, which is on the stress of the importance of analysing section 12 very carefully through the confines of the tort, which is Lord Justice Waller in Rurik against Valiant Shipping, which is in tab 24, and the relevant passage is paragraph 12 at page 2161.
So Lord Mance is page 727.
Lord Mance is paragraph 7 at 727, my lord, 727.
So what do you draw from this?
My lord, what I draw from that is the narrowness of the analysis to be conducted under section 12, which must at all times focus on the tort. On the tort. On the wrong said to have been done, we would say in this case, the tort relevant to the issue in dispute. And as you can see here, the Supreme Court stripped it down to its essential elements. If one were to ask at this case, just looking at that analysis, what it is that Nutritrek and the others did that gave rise to their liability, one can see it reduced by this court to the making of those representations in London.
Well, and reliance on them in London and the loss that flowed.
In London, yes. Notwithstanding that very many of other relevant events to the claim occurred in Russia. And indeed, the focus of the case was so significantly Russian that the application to serve outside the jurisdiction was set aside on grounds of forum non-convenience.
But I'm not sure this really takes your case any further, does it? Because nobody's in dispute. I mean, it might be said, well, they placed a real focus on the reliance and the loss, as against, as we've seen in the passage earlier, if anything, where the representation was made was slightly downplayed. But even assuming that it was given equal value, it certainly isn't saying anything about where you've got the conduct. Let's say we have the representation in one jurisdiction and the loss suffered in another. It's not really helping us on that, is it?
Well, it helps insofar as it reminds one that one needs to identify when applying Section 12 what the real heart of the dispute is that the court is being asked to determine.
Well, I think, yes, you need to be a bit careful with that because it's quite easy to slip from that formulation into a forum convenience type approach, the gravity of the centre of gravity of the dispute, which we're told from VTP is not the correct approach.
Well, it's what is the most appropriate law to govern the dispute between the parties. And that requires identifying what the dispute between the parties is really all about, what the heart of it really is.
It's about everything. Everything's denied.
Yes, and what it is, but the dispute between the parties to the litigation, the parties before the court.
Yes.
And the dispute between the parties before the court is, we would say, absolutely crystal clear why the claimants say the defendants are liable to them. I'm going to come back to that when I apply it to the facts of the case, if I may. That's why VTB is helpful, simply as a reminder of the narrowness of the task in Section 12.
Could I just, from my own perspective, to put the gloss of the real heart of the dispute into the terms of section 12, subsection 1, doesn't really assist me at the moment. It's the question is substantially more appropriate and determining all the issues in the case.
Yes, well, one of the core issues in this case is whether the defendant is liable to the claimants for what they did or they did not do. And
that's a factor which connects this the tort with this country.
Yes.
Because they acted here.
Yes.
Yeah.
I mean, again, I'm conscious, and I'm going to do this by way of a precursor to I'm about to embark upon reasonable expectation as my next point. But again, to some degree, this is a classic first instance decision. I mean, which I'm mindful that we say the judge got it wrong here. Of course, people are fully entitled to substitute their own decision. But effectively, the heart of my submission is this is a really straightforward bit of a section in a statute, designed to be straightforward, designed not to cause confusion, and the facts in this case could not be more stark. And we've listed them in writing, and I'm going to emphasise some more. So to some degree, that is my case, which is if it's not substantially more appropriate in this case on these facts, then what case could it possibly be more appropriate not to disapply the general rule? And
could I just ask you this about section 12.1, page 43? Substantially more appropriate for the applicable law for determining the issues arising in the case, or any of those issues, to be the law of the other country, and then the general rule is displaced. Am I right in reading the issues in the case as being the issues in the case on that, in respect of that tort? So in other words, you take it tort by tort by tort.
My Lord, in our submissions, no.
Right.
In our submission, the issues are a much more general nature. So to take Rurik and Valiant as an example, that was a fisherman who died on a Dutch fisherman who died on board an English registered trawler. And in the judgment of Lord Justice Waller, he says there's no question about the issue of liability for the purposes of Part 3 being the law of England. The issue is the question of the measure of damages. In particular, there was a sub-issue about the deductibility of damages. So the issue isn't the particular tort or torts. The issue is the kind of the more fundamental, more rudimentary issue of liability. Do the acts and omissions that are impugned in the claim amount to an actionable wrong? So that's the issue to which the applicable law is asked to determine.
I'm sorry,
it can't be
I'm not following this, Mr. Herman. I'm sure it's my fault. I understood you to say that in Rurik the question of liability wasn't an issue at all, and that it was
assumed, yes.
So that issue in the context of that case meant quantum.
Yes. So I'm just giving that as an example of the issues in the Act are not individual torts.
All right.
Issues are, does the underlying conduct, amount to a tort or a delict? In general terms, because of course there'll be plenty of examples one can think of in which the impugned action doesn't amount to a tort or delict, but is nevertheless unlawful under the civil law of a country whose law will be applied.
Yes, I may have probably did express myself badly. What I was really asking is whether the issues arising in the case, one adopts a tort by tort approach, and I fully understand your answer in relation to issues that can arise, distinct issues that may arise in relation to a particular tort, or whether one reads it more widely, and if there happen to be 4 torts raised in a particular pleading, whether it said that somehow you, when one looks at the issues arising in the case, you look at all 4 torts together. And what I was putting to you was that it seemed to me, subject to your submission, that one, in context, needs to read issues arising in the case on a tort-by-tort basis. In other words, because you're trying to work out what is the applicable law in relation to that tort, and whether the basic rule in Section 11 has been displaced in relation to that tort, it seemed to me to be natural to read that as one reads in the case on a tort-by-tort basis. But I wanted to see whether you disagreed with that.
Well, my Lord, in our respectful submission, that's the better way to approach it, we'd respectfully submit, is not to fixate upon the English tort or the individual English torts relied on and their own particular peculiarities and components, but to look at the underlying conduct that is impugned by those torts. And there will be cases, and VTB is one of them, in which there is different conduct by the parties that will give rise to a case in which it may be appropriate to apply the tort of one country or the law of another country. So, for example, the different conduct in respect of deceit that led to the conclusion it was English law, there was different conduct within that case that led to the questioning as to whether actually Russian law might be appropriate by Lord Mance and Lord Neuberger. In this case, it's the same conduct that is relied upon in respect of all of the torts. So there's no difference in respect to the conduct that's relied on when we plead misfeasance or negligence or trespass. It's all about seeking to have information extracted. It's exactly the same.
Thank you.
And that should be the focus in our respectful submission.
And when it says substantially more appropriate for the applicable law for determining issues arising in the case, are those issues therefore legal issues?
Yes, my lord.
Yeah.
Because you don't need an applicable law to determine fact. That will just be a fact-finding process by the court of the forum. So it's only required in respect of legal issues.
Well, do you you have certainly evidential laws for determining.
My lord, yes. And what would normally happen in conflicts is there would be a divide, which is maintained by the Act, between matters of substance, which would be governed by the applicable law under Section 11 or Section 12, and matters of procedure that will always be governed by the court of the forum. And
certainly case management and how you set about setting out a claim. But is evidential rules a matter of procedure?
My lord, it's treated as such.
Yes.
And I'm just struggling to think of any case in which the court has considered that it wouldn't be. But it's certainly treated, my lord, as a matter of procedure of the courts of the forum, of the Lex Fora, I beg pardon. So the issues to be determined here are not the factual issues in dispute under Section 12.
It'd be rather unusual if you had, if the evidential rules were the rules of foreign jurisdiction.
Yes.
They mightn't pay so much attention to the privilege of Parliament than we do.
Well, I'm going to avoid the temptation to respond to Sir James on Article 9, and turn, if I may, to my fourth point, which is about reasonable expectation. As Dicey has highlighted, it's an underlying conceptual justification for our conflict of rules framework generally. Underpinning it are the principles of fairness and predictability. But in the context of tort law, and in particular the law governing personal injuries overseas, we say that the underlying principle of reasonable expectation is of particular value when one wants to understand why it is we have the presumption in section 11(2)(a), and it's also helpful for when the court comes to calibrate the appropriateness of applying a given law and the significance of factors that may tie a tort to or from a particular country. It doesn't dictate an answer in a given case, but it helps illuminate and to be an important cross-check. And in the overwhelming number of personal injury cases, it will be obvious that the most significant factors inure in favour of the application of the law of the country in which the damage was sustained. The general rule will be entirely in accordance with the reasonable expectations of the parties, either what they were or what they should have been. And the obvious example is if I travel to Rome, the reasonable expectation that when I travel on the roads is that I'm going to comply with Italian road traffic law. And if I cause an accident, my liabilities are going to be assessed in accordance with Italian law. That's all about reasonable expectations. In cases of that nature, of which there are very many before the court, parties know or ought to have known what the rules were when deciding to travel or to do business in a country. The close connection of the country of damage is obvious. It arises from a voluntary and deliberate choice on behalf of the parties to be present in a foreign country. By voluntarily walking onto the pitch, the parties can and do expect to be governed by the rules of the game. Nobody can complain of lack of predictability or unfairness when those rules are subsequently applied to them in a tort claim arising from a failure to comply with the rules of national law. But by equal token, we'd submit, when there is a complete absence of reasonable expectation that the laws of a country in which the damage sustained would govern the behaviour, the absence is not simply a neutral factor, but one that is capable of materially reducing the weight that would otherwise be accorded to the country under the general rule. Since the general rule embodies an assumption that in most cases parties would reasonably expect that the country where the damage occurred is also the damage whose laws would apply, it follows in cases where that expectation does not apply on the facts, the assumption underpinning the general rule does not either. In those cases, the conceptual justification for applying the law of the country where the damage occurred does not exist. One example, which we cite at paragraph 32 of our case, is that given by the Joint Law Commission report at paragraph 4.94, page 1666. I don't ask you to pull it up now, but you'll see that that's where the location where damage sustained was merely fortuitous. For example, given by the Law Commission, when a ship is in the territorial waters of a country in which the parties have no interaction, and the ship is simply on an innocent passage. And the same point would apply with at least equal force, we submit, where a party or the parties were unaware, either by happenstance or design, of which country they were in. A similar effect, if one party or both parties ought to have had a reasonable expectation that the law of another country would apply, that again can be a powerful factor in the assessment under section 12. And in those circumstances, a party cannot reasonably complain that it would be unfair to him or her to apply that law. All the more so when the law that would be then applied is the law of the country of their domicile in which relevant acts and omissions took place.
I wonder whether it's right to say that the general rule in section 11(2)(a) is predicated solely on reasonable expectation. And part of the object of having a general rule is to give a degree of certainty by reference to objective factors. And that, I mean, it might be said that doesn't fully drop out of the picture just because in some cases there is a congruence between reasonable expectations, but in other cases not. The place of damage is always going to be a connecting factor, and it may be of assistance in giving a degree of predictability and certainty in the operation of the rule.
Yes, my Lord, I accept that.
Okay.
Yes, I accept there's a value in itself of the degree of predictability that is provided in Section 11. And that, in turn, gives us an insight into why the test for displacement is set high. But it remains our submission that reasonable expectation helps illuminate why Section 11 has been set in the terms that it has.
And I ask, what is the source of your submission, or upon what do you base your submission in particular, that reasonable expectation is a convenient or appropriate calibration when we come to consider the operation of Section 12?
So, my Lord, as we set out in our printed case, we derive the proposition from both Dicey and the Law Commission, and I'll give my Lords the reference in a moment.
Yeah.
And it reflects also, to some degree, certainly in the realm of personal injury, sort of common sense. Makes sense because in the vast majority of cases, injury is going to be sustained in a foreign country in circumstances in which it's obvious why the law of that country is going to govern any dispute arising. But what my Lord won't get in English conflicts of law, in contrast with some continental countries, is a kind of a deep theorising. So you'll see, for example, in the passages in Dicey that are in the bundle, a reasonable expectation is given as a basis, as an underpinning, but in a paragraph, and to same effect within the Law Commission. But it does provide, in our respectful submission, when just seen through the plain language of Section 11 and 12 taken together, a proper basis for interpreting them and cross-checking as to whether the results reached under it are sensible, correct, fair.
And am I right in thinking that in this context, the reasonable expectation really boils down to you're voluntarily in a country or you're not?
Yes, or you have no knowledge of which country you're in.
Or you don't even know which country you're in.
Or in respect to the defendants and the test under Section 12(1)(b, that you are operating under laws of this country. Those are all factors. So the reasonable expectation that you're governed by another law is certainly a factor.
Just on the tension between reasonable expectation and predictability and certainty, I wonder whether it might not be said that, first of all, the statute doesn't speak in terms of reasonable expectation, and whether one might go further and say that the test that has been set down both in Section 11 and Section 12 deliberately, to an extent, eschews it, because reasonable expectation may be something about which there could be a lot of argument, depending on the circumstances of a case. Whereas if you want a rule which is certain and predictable, it might be thought that you're best avoiding those sorts of arguments and going for more objective criteria in terms of the law that's to be applied.
Well, my Lord, the facts that go to reasonable expectation are highly germane to the express statutory test. So I didn't know about the country, or I did know about the country, but I was applying different rules. Those are all perfectly legitimate factors. My simple point about this is that one can kind of step back and kind of look in the kind of through the theory of it, and that probably takes you to the same place. And if nothing else, demonstrates why those factors are relevant when you apply the tests under Section 12 and the comparative analysis under Section 12.
Yes, thank you.
It certainly doesn't exclude factors going to reasonable expectation.
I just find it a very difficult concept to pin down. And I understand when one is substituting a concrete meaning to it in the way that you've been trying to do. But, I go to France with a friend. My friend is driving. My friend is English. negligent driving, I'm injured in France. Well, what's my reasonable expectation? I mean, it becomes almost meaningless. We've got really no idea how to answer that. So don't we have to then think of other factors like, well, you voluntarily chose to go to France, but you're both English.
Well, you know what
the reasonable expectation doesn't, to me, really help very much unless you concretise it.
If my lord goes to France, then when you travel down the highway and you're stopped by the gendarmerie for doing 100 kilometres an hour in an 80 kilometre an hour speed limit, my lord will know immediately from the rules of the game in France that you were bound by those French rules. That's the reasonable expectation when you go there. If you are injured in a road traffic accident, you know that the law that will govern the recovery of damages in that accident will be the law of that country. That's kind of the reasonable expectation. Now, to some degree, this is about labels, and it doesn't matter on the appellant's case, ultimately on the facts of this case, because the facts are so stark. So whether you want to say, put aside reasonable expectation, just looking at the bare statutory words as to the connection with a country. If I don't know which country it is, that's not much of a connection. Or if the relevant acts and omissions occur here governed by English law, that is a solid connection under 1B, 12.1b. Shorn of any reference to reasonable expectation, then on the appellant's case, fine. Because it does, I beg pardon, the respondent's case, fine.
But your analysis starts at a different point. You say, first of all, we have to strip this down to the essential elements of the tort.
Yes.
And at some point you're going to start with those, and in your submission, give us what you say are the essential elements of the tort here.
Yes.
And why that may fall within Section 11, but that there are other factors which are so significant that connect the tort with this country.
Yes. And that's going to be part 2 of my submission. So all I was seeking to do was kind of set the framework. And conscious I'm before this court, try and give it kind of a theoretical underpinning. Whereas the heart of my case remains effectively a straightforward proposition that on the facts of this case applied to this statute, there's only one answer. And so, to some degree, this is window dressing, but it's important window dressing, we say, because it's always important to look at a statute and not simply say, what does it do, but why does it do it? Because that helps sometimes illuminate the answers. And that's all I'm seeking to do by identifying the concept of reasonable expectation, so that my lords have that context. But ultimately, this case and this appeal is won or lost on part 2 of my submissions, which is the facts of this case applied to this very straightforward statute.
So you say they're going to have to wait until tomorrow morning for part 2. So you give us
the bad news is, I'm afraid,
overnight.
It's called skillful advocacy.
the bad point, my lord.
I interrupted, my lord.
No. I was just saying that you put in as a potential factor expectations, reasonable expectations, as it coming in at that stage, rather than the reasonable expectations being a factor influencing where it is substantially more appropriate to have for the applicable law to apply.
It helps illuminate the answer to that question. When you carry out that balance.
The second question.
Yes, it helps illuminate the balance on that.
Yeah.
So, my lords, I've done. That's all I wish to say on reasonable expectation. I've got 2 more short points on part 1, albeit I thought my last one was going to be short. But that's all I have on that. Then I've got part 2, which is the facts of this case, and there I am going to focus on the actual statutory test, and the factors that go for and against it on those connections, before looking very briefly at the High Court and very briefly at.
Thank you, Mr. Hermer. We'll adjourn now. We'll resume at 10:30. Very grateful to you all. Thank you very much.